A will versus a living trust. What do you need and how are they different? My name is Michael Pevney. I am an estate planning lawyer. I set up estate plans for California families. I specifically practice in Orange County, California, but I do cover the entire state. And even if you don't live in California, some of this information may be helpful and may apply to you. Something that you can do, obviously, if you like estate planning information or this is something that you're interested in, you can follow me. I've got about 1,000 videos out there or so regarding estate planning, but even more importantly, ask an estate planning question in the comments. I'm able to get back to many of those, and I might even answer your question by video. So if you've been putting off estate planning, basically what happens to your stuff in your body after you die, because you can't choose between a will and a trust, this video might be for you, and we're going to go a little bit deeper into what each of those documents are and what each of those documents mean. So what's a will and what is a trust? So a will is a document, a last will and testament, what you want to happen to your property when you pass away, where you want it to go, who you want it to go to, and it can also do a couple of other things. It can nominate guardians if you have little kids and you pass away, who you want to take care of your kids, and even a conservatorship if you have a dependent adult that you care for. And it can also list final instructions, essentially what you want to happen to your body when you are gone. And a will is very good at that. It's good at dividing property and it's good at expressing your wishes. There are some things that it's not very good at, and we're going to talk about that in a moment. What is a living trust? A trust is a document that controls property that you put inside of that trust, like real estate or like financial investments, both while you're alive and incapacitated, and then once you pass away. It does not appoint guardians. It does not give final instructions, what you want to happen with your body, cremation, burial, that sort of things. It does some of those things. It does not have the power of a will, but it has, in many ways, some advantages over a will. And I'm going to tell you at least why most people in California and most of my clients I do set up a trust for. So here are the big differences between a will and a trust. First, cost. A will has to go through probate. Probate is the court-controlled, government-approved asset distribution system that your estate, your property has to go through if you pass away either with no estate plan at all, or even if you have a will, it has to go through court. And depending on where you live, and where I practice in California, it can get quite expensive. And that can be difficult because you're not paying it. The people that you leave behind end up paying the cost of probate. And for most homeowners in California, the cost can end up being around $50,000 or so. And that's money and property that would not be inherited by your loved ones when you pass away. So that is one difference between a will and a trust. A will must go through probate. A trust avoids the probate system. So the cost associated with that is quite different. Second, control. With a will, you do control where your property goes when you pass away after it goes through probate. But after a judge orders that the will is a good, well-written will and is according to the law, the people who inherit, your beneficiaries, inherit those things with no strings attached. So if you pass away and you have kids that are 18 and 20 and 25 years old, and all of your property is split 3 ways, they get that money with no strings attached, regardless of how good they are with money, how responsible they are. They can do whatever they want with that money, with that property. You can't really attach strings to it. You can't say this can only be used for this can only be used for that. A will doesn't give us that power and that authority. A trust, however, does give us that authority. And we can say, I only want this money to go to my kids as soon as they turn 25 or 30 or 40 years old. And that does a couple of things. First, it can pay for basic needs. The trust can pay for basic needs before they reach that age, paying directly for things like basic living expenses, healthcare, education, and without the kids making bad decisions with that money, because it's going to go directly to pay for those things. And then maybe if they reach a responsible age, or they get an education, or they're starting a family, or they have a responsible job, then we can have that money go to them at that point. Some people say the frontal lobe of the brain doesn't fully mature until you're 25. A lot of times I think it's older than that for kids. So if kids are inheriting when they are young, especially if the people they are inheriting from are their parents and they've passed away, not only are they grieving, but they might get a lump of cash in their hands and not know what's best to do with it. So sometimes having some strings attached is a real benefit that a trust can have over a will. The third difference between a trust and a will is privacy. A trust is a private document. That means nobody gets to see it besides you when you create it, your beneficiaries, and any financial institutions that you might be a part of. A will, on the other hand, has to go through court. And when things have to go through court, that means it is open to the public. Anybody that has any sort of interest in who's inheriting what, they get to see because it's all open to court record. A will must be, typically the original will has to actually be filed in court. Ads have to be taken out in a newspaper in California still, like an old-fashioned black and white newspaper. You have to run 3 ads in 3 consecutive editions of your local paper. And anybody that is interested might know that younger people are inheriting a good chunk of money. Some say that financial predators out there could take advantage of somebody that's not only lost someone close to them, but is also getting a potentially substantial inheritance. So that's another difference between a trust and a will. A trust is private, a will is not, because it has to go through court and is open to the public. The fourth difference between a will and a trust is the amount of time it takes for people to actually get their inheritance. With a trust, if things are being left equally to kids or to charities or to wherever you want things to go, it gets to them pretty quickly, usually within a couple months on the outside, even sooner than that. But in California, when a will goes through probate, it's typically a year to a year and a half for a pretty simple estate, and considerably longer if it is a more complex estate, if we're dealing with rental properties, business assets, that sort of thing. It can take a few years, and if there's any sort of conflict, if people are fighting against each other, that can be quite difficult to deal with. So the amount of time that it takes to actually distribute your stuff to your beneficiaries when you pass away can be quite different with a trust and a will. Now, all this is leading me to saying why a trust can be better for people. Now, a trust isn't necessarily for everybody, but I believe that a trust can be better for people and is typically the central and main estate planning document that I create for my clients that are either real estate owners, you own your primary home just because the cost of probate is so high and it takes so much time, or they have little kids, or kids that are younger adults, maybe under the age of about 30 or so, and we want to get things to them in a responsible manner. So those are the types of people that I really like a trust more than a will. I'm almost always going to recommend a trust as that main estate planning document. So oftentimes a will in those situations, if you own real estate, primary residence, rental properties, a business, or have little kids, a will oftentimes is not going to be enough. Even when you have a trust, by the way, we still have a will. It's a very simple will. It's what's known as a pour-over will, not P-O-O-R, P-O-U-R, meaning like anything that doesn't make it into the trust while you're alive or as a beneficiary pours over into the trust. So the beneficiary of the will is the trust. Now, who are the types of people, at least in California, that a will might be a better choice? And what another benefit of a will over a trust is, yeah, it's probably going to be a little bit cheaper. The cost might be a little bit marginal. It also, of course, depends on how complex your estate is. But if somebody has responsible adult children and doesn't own real estate, and almost all of their assets are in financial accounts, we can avoid probate almost completely by naming beneficiaries on all of our financial accounts. checking, savings, non-retirement investments, retirement investments, and life insurance. I think that's 6 different types of accounts that we can name beneficiaries on. For bank accounts, sometimes it's referred to as a POD or TOD, pay on death or transfer on death beneficiary. For other accounts, we just call them beneficiaries. And that is actually a good way of avoiding probate. And we can also have a will that anything we missed out on can be left equally to our kids or to other relatives or to charities or to close friends. And that can avoid a full probate if in California, the probatable assets, and when I say probatable, that means something that isn't in a trust or doesn't have a direct beneficiary named that is alive. If that amount is less than about $200,000, we can avoid a full probate. So a will can be a little bit more appropriate and perhaps more appropriate than a trust in California if we don't own real estate and most of our assets are financial assets that we can name beneficiaries on. And so that's generally the difference between a trust and a will. The main things: cost. We want to avoid probate, and probate can be very expensive. Control. A trust gives us much more control over a will, especially if we're leaving things to people that aren't ready to get a huge inheritance, or maybe we don't like the person they're married to. Time. Because the probate process takes a long time, 18 months to 2 years or so, and privacy. The court probate process is open to the public. A trust is handled privately, but in some circumstances, a will can be the most appropriate document. So I appreciate you listening to everything that I said. If you live in California and it's time to get that estate plan set up, you can find a link in the comments here to find me and set an appointment to talk to me about setting up your estate plan. Please leave an estate planning comment in the comments. Ask a question, I'll answer it. Follow me for more estate planning information. If this was of any benefit to you, of course, like this video and keep watching my stuff. Almost any question that you have about estate planning, you're probably going to find in one of my videos across whatever platform that you are watching this on. So again, thanks for your time. Thanks for your attention.